Hello and welcome back to Easy GST for you. I'm your host Girish Kulkarni, and today we are going to discuss one important aspect related to GST provisions, specifically related to input tax credit, which is based on the recent High Court judgment of Bombay High Court at Goa, which is in the case of Umicore Autocat India Private Limited, and this specifically is related to the transfer of ITC in special circumstances, which are like merger or amalgamation, etc., covered by Section 18, subsection 3 of the CGST Act. But the larger point which I would like to highlight in this particular video is related to one common problem which is observed by many of the taxpayers, which is related to utilization of input tax credit pertaining to one state in another state. I will explain this one with one example. So, for example, let's say if a taxpayer is registered in the state of Maharashtra, and the employees of the taxpayer are traveling across the country, that is India, into various states. And let's say if the employees travel for marketing purposes or some work purposes, business purposes in the state of Gujarat or Madhya Pradesh or Karnataka, then as per the provisions of place of supply rules, the accommodation services provided by hotels in these different states charge CGST and SGST component. They cannot charge IGST. And it is often complained that the taxpayer registered in Maharashtra is unable to avail the input tax credit, which is in the form of central and state GST of other states, because a the reasoning that is given usually is that it is the tax related to the respective states of Gujarat, Madhya Pradesh or Karnataka, and B, the GST network doesn't allow claiming of or availing of such input tax credit. So I think it is very unfair, because the considering the scheme of GST law with an intention to make eligible flawless credit of input tax credit, restricting such input tax credit solely on the reason that there is no provision or there is no facility on GST network to avail such credit would be very unfair for the taxpayers. And I feel that by this judgment of Bombay High Court of Goa bench, we have achieved one step in the said availment of free availment of input tax credit. Because in this particular judgment, if we have to see the facts of this particular case, there was amalgamation which was arranged in the entity which is registered in the state of Goa with the entity which was registered in Maharashtra, and the resultant entity which is in the Maharashtra, to which the ITC credit balance, that is electronic credit ledger balance of Goa entity, was tried to be transferred, but the GST network did not allow the such kind of a transfer. So the components of such electronic credit ledger were IGST, CGST, and SGST, out of which IGST and CGST portions have been allowed by Bombay High Court to be transferred to the resultant entity, which is in the state of Maharashtra, stating that the resultant entity is very much eligible to avail and claim the credit of input tax credit. Uh, the issue which was faced that a GST network did not allow the such kind of a transfer, and B, as pleaded by the representative advocates of the respondents, they tried to interpret the provisions in such a manner that the scheme of GST law does not allow such kind of a transfer. But it was not accepted by the court, and court, by analyzing the entire framework of GST from registration till input tax credit provisions of section 16 to various other provisions, I think has gone into deep dived into detailed setup of GST law, and has interpreted the provisions stating that there is no specific restriction inserted by section 18.3, which deals with such cases, special cases of amalgamation, transfer, etc., to transfer the credit from one state to another state, and hence the credit of central and IGST should be allowed to the resultant entity in this particular case. Further, it also made an important remark by quoting a few judgments of Privy Council, stating that a court does not have power to make legislation. It can only interpret the law as it is, intended and drafted by the legislators. So this is also very very important, because the challenges which were raised by the respondents advocates were mixing up few provisions referring to certain provisions of the law which probably were not relevant to to this particular provision. But I think it was a very good judgment, and I think this will be the first step in ensuring the flawless credit of input tax across the states. I think this video will help to understand the important judgment related to Umicore Autocat India Private Limited, wherein the ITC was allowed to be transferred from one state to another state in cases of amalgamation, transfer, etc. And it was ensured that there is no loss to the taxpayer in terms of cascading effect of the non availment of input tax credit. So thank you so much for watching this video. Stay tuned.